Joshua, say, you stand in front of the judge. There's no fun. No fun. When I saw people sitting down,
Okay. We've got an indictment here, 25 CR 1791, that accuses Michael Wayne Osborne, that's you,
Yes,
correct, of the state jail felony of burglary of a building. And it also alleges that you have a fire forgery conviction out of this court in 97. And then paragraph 3 goes on to allege that after that 97 conviction of forgery was final, you committed the offense of unlawful possession of a firearm by a felon and were convicted of that in Orange County, Texas. So this state jail felony then becomes punished as though it was a third or second, because they're in sequence. If you don't interrupt me, okay? That's rude. And we can't all speak at one time. Hold on, you're going to get a chance to speak. So this appears to be indicted as a state jail felony, though it's punished as a second degree felony if found guilty. So you are looking at no less than 2, no more than 20 years confinement in prison, and a fine up to $10,000 can be assessed. Do you understand what you're facing in this charge? Now you can speak.
I do.
Okay, good.
Yeah, well, I guess I started off.
There are several things that you filed here. Let's see. You got a motion to dismiss counsel that you filed. What was the date on this? I don't see it's undated. And that Miss Manaldi has been appointed to represent you. Are you able to hire your own lawyer?
No, I filed a motion to proceed pro se and to be admonished. I also filed a motion for recusal of
I
this
know.
court.
I just asked you a question, sir. Just, are you able to hire your own lawyer, though? I'm just
I'm
trying.
proceeding pro se.
This is yes or no. This isn't a hard one to figure out, sir. Are you able to hire your own lawyer if you wanted to, though?
No.
Okay, because you're in jail and you don't have an income. All right, you're indigent then.
Yes.
Right, okay. All right, we're going to take these one at a time. Motion to dismiss counsel here. Why do you want that? Because this lady is here to represent you. You believe you could represent yourself better? Is that what you think?
Well, I'm sure you're aware, Judge, that I've been through this before and I represented myself. I have no problem with it. It's a barrier of communication when she offset this case and didn't network with me. Then I didn't want this presiding court even to adhere to the alleged offense. I don't want to be tried before this court. Not with you presiding.
Why is that?
Well, if you don't recall, you should remember 8-9 years ago, you refused my agreement, and then you still sentenced me, and you never gave me my back time. And I don't see how we can entertain this today when I filed a motion to recuse and you still entertaining the kid.
Yeah. Well, first of all, back time. I don't have number one. You're so wrong, because back time is not in this court's discretion. It's law. If you have time credited, you have to be awarded to this. And the court has never in 20 years denied back time that is allowed by law. So that doesn't make any sense there on that one. Number two, you can certainly represent yourself at any time if you wish, so long as you are completely aware and appreciate that the people who represent themselves pro se generally are not successful because attorneys are more profoundly aware of the rules of evidence, the penal code, the code of criminal procedure, and other laws that are used in the trials. Representing yourself is always a disadvantage. That's why it's a long statement. People who represent themselves have foolish people for their own clients. That was something that was part of uh, the history of law before I was born, because there's not a lot of success at doing that. And when you're not adept at the rules of law, then you have a disadvantage. But you're an adult, you get to make your own choice. If you want to represent yourself, you just have to know that when you represent yourself, you're going to have to follow the rules of law and the evidence and the court of criminal procedure and the rules of criminal procedure and the penal code and any other rules that may come into the trial process. Let's see. And you'll be able to represent yourself if that's what you clearly want. Have you ever represented yourself in any criminal proceedings before?
Well, I'm sure you are quite aware that I have.
No, that's just yes or no. And just play like I haven't had 50,000 defendants in this court.
Wow.
You're going to have to refresh my memory. Go ahead. What have you done? What's your experience in representing yourself?
I started out with, Your Honor, with the fact that I filed motions that the court is not adhering to, and it seems to me that you're depriving me of due process because I don't want this court to preside, you to preside over this case.
Well, when you have good cause, just because you don't want,
Okay.
if
Rule
do you want to interrupt me all day? We can't both speak because when you speak over me, this lady can't take what you're taking down, what you're stating. And it's rude, number one, but it's impossible for her to take what you state. Let me speak, then you'll get an opportunity to speak. Okay. All right. Look, the Constitution of the United States does not state you anywhere that you get the choice to make your joy, to have a judge of your wish before you. And that's, you get a judge who is a lawfully presided judge, and that's what you get. Just because you don't like me to preside over your case, that's not enough to grant your wish. Then I have a motion to quash an indictment here that you have filed, and can you summarize the reason that you filed this?
That was predicated, Your Honor, because it fails to state, I don't have a document, probable cause, information, or anything to go by. And first of all, I never entered any building, broke into any building.
But that's not, that's what we deal with at trial. But the four corners of the indictment, what's wrong?
All four corners, it doesn't meet the element of burglary of a building.
What does it fail to state? Because it states
giving notice that I fully entered, partially entered, something to that effect, in which that would probably give me the benefit of defending myself against.
Okay. In summary, this states the elements of the penal code of burglary of a building clearly in this paragraph that on or about October 15th, 2025 in Jefferson County, Texas, with the intent to commit theft, You intentionally and knowingly entered a building or portion of a building not then open to the public without the effective consent of the owner. Those are the elements of burglary of a building. Anything else? What was it missing? What was the element that's missing that's in the penal code that you're saying?
Into the building.
Oh, but it's an allegation, sir. It's not, that's what we do at trial, whether you, it alleges, it's what the allegation is. That's why we have a trial, and that's why you get to present evidence, the state presents evidence, and a jury makes the decision. Everybody who pleads not guilty contests what it says. The question is the four corners of the indictment. Does it allege the allegations that are required for the commission of a crime? And it does. That's why we're going to go to trial. So that's denied.
Yeah.
The motion to quash is denied. It does
I'd like a copy of that.
properly fit the elements of the indictment. And you filed it more than once here. There's a motion to quash on December 19th. What's the difference?
I never got an answer. This is why I refiled it.
That's why we're here today. Your the motion is denied.
This
Let's
is
see.
nothing but
Wanting to
criminal
advance pro se. What, you're just so rude. Interrupt the court. I told you you have a chance to be heard, sir. You can't help yourself. How many times well, we learned that in second grade. Not that our teachers would scold us. Don't be rude to others and don't speak over others. You're going to get a chance to speak. Okay. Wanting to advance pro se, that's granted. You're going to get that. That's all. Now that's all I have here. The motion to quash, hold on. The motion to quash is denied. The motion to proceed pro se is granted. That's another pro se. That's granted. Motion to dismiss counsel. That's granted. Anytime you want to change your mind on that, though, I would urge you, let me know so a competent attorney can be appointed to represent you. Does he file something? I'm sure he's not able to pay, and Mr. Osborne is deemed a transient. Is there something in here that shows he's indigent, though, so that we can appoint somebody? There is an affidavit of indigence that was never signed by you. That needs to be filled out.
Yes, sir.
So that if you, and it looks like the magistrate, it looks like Judge DeRuin
Yes, sir.
went over it, but you wouldn't sign it or fill it out.
No, I filed to proceed pro se, and I filed for an examining trial. I requested one immediately.
Okay, but here's the deal. Anytime you want to change your mind, which is the right you have under the Constitution, to have a lawyer represent you, what would happen, we'd have to stop everything we're doing and get you to fill out an indigent form. If you fill out an indigent form now, it's in there ready to go in the event you change your mind.
All right.
But it's your call if you don't want to do that, but it stalls everything, you know. I would urge you to do it just to have it as a safety. Okay, sir?
But one thing, did you get the motion for an investigator? I sent that as well.
I'm looking at all of this. And okay, motion to dismiss. There's no investigator in that. Then the pro se motion to quash the indictment. Another motion to quash the indictment. It says wanting to advance pro se. I'm treating that as a motion for pro se, and I don't have it. That's it.
Okay.
That's all I've got here. Um, and then here is there's something about this says motion to recusal, and then it refers to Judge DeRuin, though. Establish the wanting for examining trial. Is that right? Is that
Yes,
what you-
sir.
Okay, you don't get an examining trial if you have been indicted. If the grand jury indicts, which they've indicted in November, an examining trial is no longer an option. Says you are illegally confined in the jail. Information indictment that's paramount. It said John seems to stop. What is that? Step aside, I think is which is some paramount importance. The leading force of this matter is predicated on facts and a profound complaint. Further complaints presented before Mr. Stevens made Stevens' failure to not accept the plea agreement in the state felony in the past. From what has happened. First, what may happen. Articulates the presiding judge. The decision years back in a state jail case. I guess it was in this forgery case. Is that right?
Recusal, yeah, that,
Yeah, okay. Okay. Which I really can't read your.
I know.
Where premise is considered prevalent that said judge step aside in the best interest of justice. And I don't understand your writing because it's hard to write in there, but I don't understand what you are articulating that would cause this court to step aside. It seems to state you just don't prefer me, and that's not enough, under law. But if you want to write some more, go ahead. But at this time, I don't find that the four corners of your pro se motion sets forth valid reasons for this court to step aside.
Okay.
So we're going to continue to move forward, and you want to continue to represent yourself.
Yes, sir.
All right.
I would like
And you want to go to trial.
right. I would like copies of all that's been denied as well. And a copy of my indictment, copy of the cause and information if at all possible, yeah.
Yeah. Okay. If Reggie, can you make just a copy? As possible, at any time you want to change your mind, let me know immediately so we can get somebody in here. Okay. Yes, sir. All right, sir.
Thank you.
All right. Thank you. What else?
Judge, did you need him to fill out this imaging then?
Yeah, he needs to do it now while we've got him here. Anything else?
No, Judge.
Is that it? All right. Who else do we have? All right, we now call pause number 22-39418, the state of Texas versus Charles Ray Moss III. That's you,
Yes, sir.
present. Mr. Gertz is here representing you, and the state's counsel is here, Mr. Ham. Earlier in this case, you were indicted by a grand jury for the first degree felony of murder. You entered a plea of guilty to the lesser included second-degree felony manslaughter. And a pre-sentence report has been ordered. Have the parties had an opportunity to review the pre-sentence report? Any corrections or changes to it, state
None from the state, Judge.
or defense?
We have, Judge, and we do not have any changes or corrections.
Made a part of the record for all purposes. The agreement is a cap of 15 years, I believe, correct?
Yes, Judge.
So you are looking at no less than 2, nor more than 15 years confinement in prison. I don't believe regular probation is an option.
That's correct, Judge.
Deferred can be.
Yes, Judge.
And there are some things I highlighted here that I'd like the parties to address during this hearing, and the defendant may want to if he wishes. Okay. Go ahead, state, if you want to go first, or you can go last.
I'd like to go last, Judge.
All right, defense, go ahead.
Judge, we're asking the court to consider deferred probation in this case for a couple of reasons. One is Mr. Moss is not even though he did engage in a fight with the decedent prior to the shooting, he is not the person who shot anyone. I don't think that's anyone's contention, but he was obviously a participant in this episode. Secondly, though, Judge, he has very limited criminal history. In fact, just has a possession of marijuana out of Smith County, but other than that, has little or no criminal history. And then, additionally, Judge, he's been in custody now. I want to say for almost 5 years, if not at 5 years, on this charge, and so that's a significant amount of time under his belt, so to speak.
Well, this has occurred on February 17th, 2022.
Well,
The most he can have is 4 years.
4 years. Either way, he's been in custody since within a few days of the shooting, Judge. So I miscalculated that. I apologize to the court. But for 4 years, he's been in custody on this, and it seems to me it would be logical for the court to consider supervising him over the course of that 10 years of deferred adjudication and trying to help him get on the right track with his life and making better choices and things of that nature, as opposed to merely just giving him a prison sentence and letting that be the result. So we're asking the court to give consideration to that option, which again would, if he were to violate it, we've talked about it very thoroughly. If he were to violate his probation, he understands the severity of the consequences. He understands that the 15 years in the cap would go away, and instead he would be facing up to the full amount, which would be 20 years in this case, Judge.
Right, so I'm going to provide a little background so we can put this in perspective, Judge. There's 3 individuals that were charged with this offense. Specifically, Jacoby Broussard took a plea bargain agreement of a cap of 30 years to the murder offense. That was he was pled on October 6th of 2025. He came back on his sentencing on December 1st, and he received 30 years. It was at that time as well that we moved one of the other cases, Arthur Small, who in my opinion had less involvement than Mr. Moss. He received a plea for manslaughter and accepted a sentence of 8 years TDC, and that was subject to his testimony that was going to be offered against Mr. Broussard and Mr. Moss that directly contradicts what the defendant's version on page 1. Mr. Moss, we fashioned an agreement with him to allow him to plead to manslaughter as opposed to murder, again, because of not being the shooter at the time as far as the state's understanding of the evidence, but the fact that he was actively involved, participated in this, and again, specifically, what's highlighted on page 1 is that he was there, he observed it, and I know Your Honor's read the statements of the interested parties. The fact that someone could walk away from that and not do anything and then really stand here and ask you for probation is, I understand why they do, but it's just not warranted. When we look here at things from a perspective, the sentence that we gave Mr. Broussard was proper. The sentence that Mr. Small received is proper. It's appropriate that Mr. Moss receive a sentence somewhere between the 30 and the 8 years. To give him
Between what?
30 and 8. Mr. Small received an 8-year sentence. Mr. Broussard received a 30-year sentence. Mr. Moss can receive anywhere up to 15 years. And I'm just telling the court how I fashioned this agreement. There was a fourth individual that was immediately came forward and was not present at, not actively involved, and purposely identified all these individuals, and that's the reason why he went uncharged as far as these facts and circumstances are concerned. But to lessen the punishment for Mr. Moss would be highly inappropriate in this lawyer's opinion. I do agree that Mr. Moss has been in custody for the sum of approximately 4 years. I agree that he has a limited history involving this situation, but his lack really of accepting any kind of responsibility for this and a lack of remorse about what happened doesn't warrant the sentence that they're asking. I feel that 15 years is appropriate, Judge.
Okay. Go ahead. Anything you want to say?
No, Judge, I think my only disagreement with him is about the what the outcome should be. I think that you know, the court has an opportunity here to address this young man's challenges and issues, and if the court does see fit to give him 15 years, theoretically he would be eligible for parole in 3 years, and would just be out versus being on the court's supervision for an extended period of time, a much more extended period of time, and all the while having the ability, as the court is well aware, to put him back in prison for an even further extended period of time based on his performance. So I'm asking the court to consider it. I understand what the sentences were for the other people involved, but I think the court can by its verdict can supervise this person, and by its ruling can supervise this person, and be as effective or even more effective than just applying prison sentence.
One last thing I forgot to mention to Your Honor is when this was set on November 13th, it was on the trial docket. It was at that time that Mr. Moss learned that in addition to Small testifying against him, that Broussard was prepared to testify against him. So all the individuals there were about to come into the courtroom and set forth his actions. And It's only then, in my opinion, when his feet were on fire that we entered into this agreement. So we never fault somebody for waiting, but it is a fact that I wanted to share with the court.
Okay. I'm kind of funny about the presumption of innocence.
Yes, sir.
I do too, Judge.
I wrote an article on that one.
Yes, Judge.
And it's the lead article, by the way.
To be fair, I mean, we made decisions for a variety of reasons. Those people would have been subject to cross-examination and we can see what we would have landed, but he's chosen to accept responsibility for his.
That's what this is all about.
Yes, Judge.
The circumstances of the crime, criminal history, those are the equations. Those are the factors that go into the equation of determining a sentence. You pleaded guilty not to the indictment of murder, but to the lesser included offense of manslaughter.
Yes, sir.
Okay. Did you want to say anything to the court?
No,
Because, okay, because there's a big gap problem here. The pre-sentence report is made a part of the record here without objections. I want to know what you did. Because I can't understand it. It's not clear at all. You admitted, you pleaded guilty under oath to recklessly causing the death of an individual. I want you to explain to me or anybody what you did to recklessly cause the death, because according to this pre-sentence report, you didn't do a thing, which doesn't amount to culpability. Anything you want to say? Or I thought you were complete. Go ahead.
Well, I want to,
Anything else?
I'm always concerned about questions like that for my clients, but
Yeah.
I think the answer here is goes back to the rule of parties. So we make a calculation about pleading guilty, not just based on the
Okay,
language.
go into the, tell me how that connects him. That he just wasn't in the same area code. What was his connection with the party?
Well, Judge, he started the fight or got involved in the fight that started this entire process. I mean, his decisions to participate in the fight that ultimately led to the death of the decedent, even though it was someone else who did the shooting, he was there and was an active participant. And so, again, that's what the eyewitness says. It's what the other people involved.
Where's the evidence in the history of the reports and all that show where the defendant was at the time of the death? Is there anything you can?
There's statements from Arthur Small from the beginning that he was involved as an individual that got out of the car when Jacoby Broussard shot him. And that's also confirmed from the uncharged conspirator, Ladarius Stevenson. So all that's from the onset, Judge.
And the defendant has nothing more to say, right?
Yes, yes, that's it.
Okay. All right. Anything else?
No, Your Honor.
If not, your last chance, because I'm about to proceed with the rendering of punishment. Okay, it's your call.
I just want to say that I apologize for what happened.
Well, what happened?
The
That
deceased
you're
was
apologizing
the
for?
deceased was my best friend.
I know. What did you have to do with his death?
Nothing. That day I was called to go feed.
All right. All right. You just heard what he said. I had nothing to do with his death.
Judge, he is a party to this offense.
Sir, I know that. I know what he's saying, but how can he say, I plead guilty and I had nothing to do with it? Can you fix that in the record? Because it's a problem.
I understand, Judge. Again, this is why I try not to encourage my clients to have conversations with the court like this.
Well, but no, it's trying to place a square peg in a round hole. It's not fitting.
Judge, the answer again is he was actively involved in a fight with a person that was his friend, but ultimately was the decedent at the hands of another person, Mr. Broussard. And he was there. They were all at the stables that were there. But when he says nothing, he means he wasn't the person that pulls out the gun and shot anybody. He didn't pull out the gun. He didn't produce the gun. He didn't
What did he
hide the gun. Well, Judge, he was involved in the fight that led to the altercation that led to the decedent's death.
But I thought he
Only
left
one
and
person-
separated himself from that
Well,
before the event.
I don't think it's before the event, Judge. I don't think that would
Well,
not be the evidence at trial. And
Well, that's not what he just said. That's not what this says. The Shortly didn't, he had no idea who shot and killed him, found out the next day. Interviewed, we got in a fight, however, he left shortly after and did not return. I mean, I'm not a dummy. I mean, this doesn't add up to being present at the time of the event. But he pleaded guilty. All right. Anything else?
No, Judge.
Anything else from anybody?
There you go.
All right. Here, Mr. Moss, you have pleaded guilty to this lesser included offense of the second degree offense, manslaughter, voluntarily, knowingly, intelligently. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted at the hearing to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this second degree felony of manslaughter. I am following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 15 years. The judgment shall reflect an affirmative finding that a deadly weapon, namely a firearm, was used in the commission of this offense. You understand what has happened today, sir?
Yes, sir.
You will be given credit for all time you have served in accordance with this place. Anything else to add by anybody?
No, you.
All right,
Thank you.
that is all. Okay, we call cause number 25 CR 99, the state of Texas versus John, is it Philemon
Yes, sir.
LaRue? That's you?
Yes, sir.
All right, you were here and Ms. Minaldi is representing you. Do you understand that there's a motion to revoke unadjudicated probation that's pending before the court? And that was filed back on November. And it, among other things, states that you've been on probation since December of 24 for the third degree felony of evading arrest or detention with a motor vehicle. And it doesn't just allege one, it alleges 11 violations of probation, committing the offense of assault, public intoxication, criminal trespass, public intoxication, disorderly conduct, abusive, profane, or vulgar language. My goodness. Failing to report to probation, to immediately report to your release from jail when you were released, it says back in October. Failing to provide verification, perform community service hours, being at a location other than your residence at 3:15. That's a busted curfew violation in October. Public intoxication in October. That wasn't a good month for you, was it? Failing to enter and successfully complete defensive driving and failing to pay court assessed fees. Okay, it only takes one. You've alleged to have committed 11 violations. It only takes one to revoke your probation. And this is a third degree felony. So if you understand, you're looking at up to 10 years in prison if your probation is revoked. Do you understand? Serious. You have to speak out so I know. Okay. Let me ask you, do you have any history with psychological testing or psychiatric?
I'm going to be honest with you, Judge.
Well, that's a good thing here. Yeah.
I got in a wreck the 2 years ago. I got in a wreck.
Okay.
And
Did you have a head injury?
Yes, I did. And And I don't know what kind of feelings I get over,
Let me ask you, were you in trouble ever before that happened?
you know,
Ever?
No.
You weren't even arrested?
I'm not anything bad, like little.
No. That's true. Yes or no? Were you arrested?
No.
Every violation is kind of serious. You weren't in trouble at all before that arrest? Let me see.
Not like crazy.
I don't care, not like anything. I just asked you a question. Did you have criminal history before the wreck?
Minimal.
That's a yes or no? It's like, are you pregnant or not? Yes or no? Not maybe, I'm a little
No,
pregnant.
I mean, I'm just small history, so.
Small criminal history. There's such a thing.
Yeah, I mean, I was good for a long time. I mean, I was trying to do good.
Okay, we're going back 22 years now. I'm looking at a possession of marijuana in Harris County, 3 days, assault causing bodily injury in Brazos County. And that was in 05. That was 6 months in jail. Failing to identify, that's 20 years ago. Those are, looks like misdemeanors. Hello. And then we've got, how many misdemeanor convictions do you think you have? Then you said this wasn't serious, but they're crimes. These are above Class C misdemeanors because they're time in jail. How many would you say you had? Because you know better than I do.
I can't remember, sir.
Why?
I don't know.
I would.
7, I'll say.
10. I know more about you than you do. Okay, on felonies, it looks like you were on probation in 2015 for 6 years, and then a month later it was terminated. I don't know what that means. Unsatisfactory termination of deferred probation. How does that happen? What happens?
They just decide not to revoke them.
They just gave
They
up.
just gave up. Yes, sir.
So he was not found guilty. It was
Correct.
okay. And then we've got this present case. All right. Well, here's the deal: is at least you don't have a felony conviction yet. You don't want one. You know how long those follow you around?
Yes,
How long?
forever.
And a day. Yeah. But I'm a little concerned. You're playing down misdemeanors, but we're not talking about a parking ticket here. We're talking about assaults, resisting arrest, DWIs, resisting arrest, assault. That's violence. All right. You gotta,
In my youth, I was a different man, sir.
sir,
In my youth, I was a different man.
did you know better?
Yes, sir.
Yeah. You were treated as an adult. Adults, you know better.
Mm.
Were your parents good people?
I'm also-
Okay, well, you got role modeling in the house, so that was a good example. Anyway, see if you can fix this. But it's going to take responsible behavior. Okay. And Miss Minaldi is a great lawyer. So what are we going to do today? What do you want to do today? We know where we stand on what he's facing. We've got what do you want to do today?
I do have the certified copy of his conviction on one of the public intoxications that he pled to, so that's the easy one.
Played into him, public intox. I asked
Okay.
for
She did file, I think, for an evaluation judge.
What do we want to do on that and move forward on that? I mean, okay.
I mean, the offer in the case, I believe, is 4.
That's correct.
Last time we talked, I had counter offered with 2, but I don't think that was accepted. So I think the offer is still at 4 years TDC. So the options that we have moving forward are to accept the plea agreement and go agreed to the judge, or we can set it for a hearing and
Then I'll make my
the
choice.
judge will make its decision.
And you're
Same
looking
option
at
that
up to
we've
10
talked about
years.
before.
But what happens in the calculus is that your criminal history and the circumstances of the charges play together into the equation. Your criminal history is rich, even though most of it's misdemeanors, but you're not supposed to, you're not supposed to commit crimes. Have you ever had an evaluation mentally, but in front of a psychologist or a psychiatrist or anything like that? No? Has anybody ever told you, any physician ever told you that you should have an evaluation? Well, what happened on that?
I just didn't follow through with it. I didn't
Well,
follow
I mean,
through.
do you think you need one?
I probably, I mean, it wouldn't be a bad idea.
Well, have you ever had like a head injury or anything
Yes.
like that?
I told you I got in that wreck, and after I got in that wreck, I just went.
Okay, in the wreck, what was the diagnosis?
I didn't go to the doctor. I should have went to the doctor.
Well, you can self-diagnosis.
Well, it was a bad wreck, and I walked out of it, and I knew I shouldn't have. I knew I should have went to the doctor, and I didn't go because I didn't have the money.
Okay, so what I'm going to do is grant a motion for a mental evaluation. And Dr. Edgar Pond will, the licensed psychiatrist, will come evaluate you for a competency to make sure that you don't have issues that would prevent you from clear-headed thinking in moving forward, in this case, whatever direction we take, because this is your life. And so I find good cause to grant it, and I urge you, he's a very nice man. He's the leading psychiatrist in the area, and he'll evaluate you, work with him, and be frank and forthright. Okay. That's yes or no.
Yes, sir.
Because that's the only, you got to help yourself to some degree. And being forthright is the right way to do it. Don't try to trick him. He's pretty good at catching that. But nonetheless, I'm granting it. And then we're going to come back and review this in a few weeks after that's done, and see what direction we take on Mr. LaRue. Anything else?
There you are.
That is all. Thank you.